Bryan Kohberger on or about November 13th, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder.
That is top-notch defense attorney work. So I think that she's doing a great job. It's just going to be a very tough case, an uphill battle.
Bryan Kohberger's defense attorneys are at it again, but this time they're switching up their tactics. Now they want previously sealed documents involving the accused murderer to be made public.
In a case like this, there's going to be something that is filed that is going to surprise us, I think.
By now you know the story of the 4 University of Idaho students who were found brutally stabbed to death in their off-campus home. It was November 13th, 2022 when the bodies of Xana Kernodle, Ethan Chapin, Madison Mogan, and Kaylee Gonzalez were found. The story became a media sensation, especially when the case went weeks without an arrest.
And we see this coming. Eventually, we're going to narrow in on exactly what happened and who did it.
That's just what happened in late December of 2022 when investigators arrested Kohberger at his family home in Albrightsville, Pennsylvania.
These murders have shaken our community, and no arrest will ever bring back these young students. However, we do believe justice will be found through the criminal process.
Kohberger was extradited back to Idaho in early 2023 and has been held at the Latah County Jail ever since, a mere mile and a half from the grisly crime scene. Law&Crime has followed the twists and turns of the case from the start, bringing you dozens of updates along the way. But still, a trial date isn't set for Bryan Kohberger, and because of a gag order, much of the case still remains a mystery. But that's something Kohberger's defense team is hoping will soon change.
It's a motion to unseal the motion and any proceedings and arguments that are generated as a result of the motion. So if they're going to be having a hearing on it, they want anybody that's a member of the public to be present in the courtroom and see what's happening, basically.
We sat down with public defender Natalie Whittingham-Burrell to understand the defense's most recent motion and make sense of where the case stands right now.
So I think there might be some things that end up surprising us. And you should never assume, you should never assume in any criminal case. There can always be something there that will turn the mind of the jury or make it so that certain evidence is not admissible.
To understand the most recent motion, we have to travel back to May 2023 when Kohberger was indicted in the 4 murders. Months later, Kohberger's team requested the indictment be thrown out. They argued a few things. First, that the prosecution withheld evidence that would be vital in Kohberger's defense. Next, they alleged inaccurate directions were given to the grand jury based on the standard of proof.
So the standard of proof is what the prosecution has to prove, has to show in order to establish the case at whatever process that they're at. So at the grand jury stage, that is a probable cause standard. Meaning, is there any evidence that's been alleged that this person has committed the crime in this jurisdiction and that these elements or all the elements of the crime have been satisfied? Probable cause is a super low standard. It's really kind of like more likely than not, or some evidence of it, right, with some reliability or credibility. At a probable cause hearing, they can use hearsay, which you can't use at a trial. They can introduce things that you normally wouldn't be able to introduce at a trial because the rules of evidence are relaxed. And so for all those reasons, it's very unlikely that a judge will find that the prosecution did not meet the probable cause standard before a grand jury.
That proved to be the case. What ended up happening is that the judge denied the motion. He came forward on December 15th and said, here's the reasons why, but we're going to move forward with this indictment. The next things that happened kind of bring us to where we are now, that the defense filed an additional motion asking the judge to rethink his ruling, and then now filed a motion that be made public or unsealed. Can you explain that to me? It kind of seems like a weird motion.
Right. Well, they want the case to be in the public eye and no longer want for it to be sealed. Previously, they agreed for it to be sealed. And I guess what they're saying is that whatever privacy interests that the prosecution had in doing their investigation no longer exists. And usually the default is that trials are conducted in public, but grand jury proceedings are not. Now, motions concerning the grand jury proceeding or any probable cause proceeding would normally be by default in public unless there was some type of motion to make it happen in private or outside the view of the public. So not only does the public have the right to view trials under the Sixth Amendment of the United States Constitution, so too does the defendant have the right to a public trial. So that's just him asserting his right. Now, strategically, why is it that his attorneys would want this hearing to be in public? Turning the tide of public opinion, I would say if this was a private attorney. However, the attorney that he has is, a death penalty qualified public defender. So usually we're not interested in getting publicity for our case or changing the narrative around their case. But we do, as defense attorneys, believe in sunshine being the best disinfectant. People are usually on their best behavior in court when everything is in public, and it dispels any feeling that there could be secrecy or privacy or trying to improperly hide something that should be out in the open. So there's always an interest in having a case in public. It's only really in rare circumstances where you would have things sealed and in private, except for a grand jury hearing, this is different. They're just trying to challenge what happened at the grand jury hearing. They're not trying to get a new grand jury and have that exposed to the public.
All this is a far cry from what we usually expect from Kohberger's team, who historically worked to keep the media out of the courtroom. It's something the prosecution and defense actually agreed about, limiting the number of cameras in the case. But just last week, Kohberger's defense attorney, Ann Taylor, drafted up this new motion specifically referencing public interest. The doc reads in part, quote, "Mr. Kohberger acknowledges the right of the public to be fully informed of the issues. Mr. Kohberger has a right for the rule to apply as it is written, rather than disadvantage him with items remaining sealed." My question about this dates back to the prosecution and defense both maintaining a united front on cameras. They were both saying we want to limit the amount of cameras in the courtroom because this case has had so much attention. So why the change of thought there?
Well, in the early stages of the case, I think the police were still doing an active investigation. So clearly on the prosecution's end, they wanted to keep as many things close to the chest as possible so as not to taint their investigation. On the defense's side, there were a lot of wild rumors that were flying around and people kind of being intrusive on Mr. Kohberger. So they did want to, I think, protect his privacy. But now the cat's out of the bag. We all know who he is. We all know what he's charged with. So there really isn't that need for that level of protection anymore. And I think now is the best thing to do is to keep the case in the public eye to ensure that the entire process and proceeding is on the up and up. But I really think that it's because of the public scrutiny could have, for example, if the judge wanted to do something radical and release Mr. Kohberger pre-trial, maybe because he or she didn't think there was probable cause, or they didn't think he was a flight risk or a danger to the community. A lot of people would have disagreed with that. And so maybe they wanted to give the judge, especially when considering bond, the comfort of knowing that you're not going to be under public scrutiny when you're making certain decisions. But now, given the stage of the case, it really is a good idea to keep it in the public eye. And I can see why they would do that.
I guess that kind of leads into my next question about the gag order, because this case, we've been following it practically since day one, and yet most of the information we know comes occasionally from hearings, but oftentimes from that affidavit that was released months ago, because there was that gag order almost immediately telling people not to talk. Is that something now that the defense would try to overturn based on what you're saying?
Well, it's not contained in Ms. Taylor's motion. Honestly, I think in this case, the gag order is beneficial to the defense because there is certain information that's out there that was incorrect. There are certain things that were being said about Mr. Kohberger that were later proven not to be true. And then it can kind of tamp down on some of that public anger that is generated when the families of the victims start speaking out about facts of the case, which of course, you can't really control them, but having the gag order did kind of tamp down on that a bit. So it helps with public perception to have that gag order on the the attorneys and the parties speaking to the media. But as far as the media and the public being able to go to the hearings and see what's happening is a bit different than talking about, like, for example, what the attorneys discuss in chambers conferences, or, things that would be normally behind the scene. I think that gag order being in place would be a good idea, or discussing what's inside of the discovery before the case goes to trial, because you don't want to taint the jury pool, so that they might want to keep in place. And I'm sure that's why she hasn't added that to the motion.
Whittingham-Burrell suggests Kohberger's defense hopes to allow more information to the public, but in a controlled way.
You're trying to control the flow of information while preserving your client's right to a speedy and public trial. And so I think that's the balance that they're striking here. If one day they decide that they no longer want the gag order in place, I guess that's fine. But I think it did serve a good purpose, which was limiting poisoning a potential jury pool, because, people make all types of assumptions hearing about evidence that may actually never come in at trial, because it may not be admissible or it may not be relevant or whatever the case may be. And you don't want the jury to consider something they didn't actually hear at trial.
I guess the overarching thing with all of this is that the defense is hoping to have the indictment thrown out. That's what this all boils down to. And now they're asking the judge to rethink his decision to maintain the indictments. What do you think is going to happen with that? Do you think that he will maintain them?
Oh, yes. I think the judge is going to deny their motion to get rid of, or, strike the indictment, however you want to put it, dismiss the indictment. And the reason is, like I said, that probable cause standard, right? So what really needs to be understood about grand juries is that they're almost completely within the control of the prosecution. They're non-adversarial, meaning that Mr. Kohberger didn't even have a right to be there at the grand jury proceeding. Most defendants don't even know a grand jury is being convened against them at the time that it's being convened. And so they can have basically anything happen during the grand jury proceeding. Witnesses just testify under oath without any cross-examination, and that is completely acceptable as long as they elicit testimony or evidence to say, we think Bryan Kohberger committed these elements of murder in Latah County. And as long as they do that, it's a good indictment. As long as all of the elements of the offense are alleged at the time in front of the grand jury, then there would be no reason to throw it out. It's very rare that a court finds that there is not probable cause to proceed. It happens, but it's rare. And so, especially when there's a grand jury, it's very unlikely that the court will get involved in saying that the grand jury reached the wrong decision. If that's the case, then you try it out at trial and see what happens. So I find it extremely unlikely that the judge will dismiss the indictment here. Not impossible. Strange things have happened, but I just find it extremely unlikely. But his attorney is doing exactly what she should do, which is challenge at every single step of the proceeding, because this is a death penalty case.
And it's very possible these documents will be unsealed. It sounds like the judge likely won't throw away the grand jury indictment, but I'm wondering, is it possible that he will side with the defense on making this motion public or unsealing it?
So yeah, I think it's possible the judge will unseal, because there has to be, every time that you do something in private in a criminal case, the court is going to have to make an assessment of whether or not there is good cause to do that thing. And so they're asking for that assessment now. I can't think of a reason, especially this long after the murders occurred, to continue to seal the case off from the public having any access whatsoever, especially where it's the defendant's right to a public trial and the defendant is asking for it. And so I think it's pretty likely that their motion to unseal will be granted, just not likely that their motion to dismiss the indictment will be granted.
And if this motion is unsealed, can we expect any sort of bombshells to be released in it, or would it be just run-of-the-mill paperwork?
In a case like this, there's going to be something in that is filed that is going to surprise us, I think. There is just so much here. When I read some of the motions from Ms. Taylor about the DNA and the way in which the DNA was collected like through these like ancestry websites and things like that is how they initially got to it. That gave me a lot of food for thought as to whether or not the police are going to be able to establish a chain of custody on the DNA, which is a very big issue.
Whittingham Burrell believes Taylor is going about Kohberger's case in all the right ways to poke holes in the prosecution's case. As for when we'll see that case in full presented at trial, that remains to be seen.
I think the summer is unlikely. I'm sure that they're hoping for that. And they have had the case for a while, but there are multiple victims here, multiple pieces of physical evidence, as well as DNA evidence. All of this video footage of the white vehicle allegedly going to and from the crime scene, and the multiple witnesses that need to be wrangled up, I just don't see it likely that it's going to happen in the summer. And then their motions to suppress that they're going to have and their DNA motions, those could take weeks. So I would think winter to next year. That's my prediction.
Bryan Kohberger is due back in court next week, where the subject of the motion to unseal will be discussed, as will a potential trial date. Reporting for Law&Crime, I'm Gillespie.